This video is for educational purposes only. It's not legal advice. It's illegal. You need permission. Delete your footage. These are the words used by Mitie security at London Bridge Station. But here's the truth. The law says the exact opposite. Let's break it down. Welcome back to Know Your Rights. Yesterday we explained the law on photography in public. Today we put it to the test. 3 separate security guards at London Bridge tried to stop me filming. Here's what happened. No. Here we go, here we go. It's illegal?
It's not allowed. Sorry.
Not allowed.
Sorry. You have to delete it, please.
We don't have to delete it. No, we don't.
Delete it.
Step back.
It's not allowed.
Step back.
Not allowed. It's not allowed.
Not allowed.
Hello, would you please respect yourself?
Respect myself. I respect myself all the time.
Oh. It's not allowed.
Not allowed. Not allowed.
Would you please stop it, please?
We politely decline your request.
It's not allowed.
Not allowed. This is what's not allowed. This is completely false. There is no law against filming in public. Section 33 of the Criminal Justice Act 1972 defines a public place as anywhere the public is permitted access. That includes pavements outside stations. Security guards cannot make you delete footage. Even the police don't have that power without a court order. You security guard? You security?
Excuse me.
Are you security?
Yes, I am.
Where's your SIA badge?
From railway property, yeah.
Yeah, it's not outward facing. Have it outward facing. It's not outward facing. You're breaching your licensing conditions.
Please, could you
No,
stop the
no.
recording?
I'll talk to you once you put your badge on correctly.
What's that?
Put your badge on correctly and
Don't
we'll talk
worry
to you.
about that. Don't worry
No, I
about
do worry
that.
about it. You're
Stop
breaking the
what
law.
you're doing.
You're breaking the law. Go on, get back to work. And here's another problem, is SIA licence isn't being displayed correctly. The law requires it to be visible, front facing and above waist height while on duty. Failing to display is a breach of the Private Security Industry Act 2001.
Yeah, but if you're telling you something, don't do something, you at least respect the staff that came to you. What do you do?
No, just gathering evidence.
Evidence for what?
The SIA badge is not on display.
For what?
Your SIA licence is not on display.
Is that why you're here?
Yeah. Yeah.
I've got stickers actually.
My job is to actually report security guards
Your job is to what?
for not wearing their SIA licences.
Is that your job?
Yeah.
What's your name?
What's my name?
Yeah.
Well, what do you want my name for?
Because you said you're recording for SIA.
No, I didn't say I'm recording for the SIA.
So what you do?
I report to the SIA.
You report to the SIA?
Yeah, so that's what I'm doing a big documentary,
Yeah.
catching security guards
Yeah.
that are breaching their licensing conditions.
So if you came here to do that, who did you get your permission from? Have you gone to the station?
Yeah, no, but if I go, oh, I'm coming here to catch the security guards not wearing the SIA licences, then you're all going to be wearing your SIA
No, but what I'm
licences.
saying is you don't need to tell me. I'm saying if you're here to do that.
I don't need to. I don't need
if
to
you're
tell
here
you.
to do that, you need
Yeah,
to
but
go
that's
to
the
station
point.
reception.
But that's the point. I don't need to.
You have to.
No, I don't. I'm standing in a public space.
I need to see your ID from the station.
No, I'm not in the station. I'm on a public road.
I'm gonna come.
Have I gone in there?
Have you what?
Have I gone inside?
You don't.
Have I gone inside?
I'm gonna answer your question if you listen to me.
Okay.
This is just a conversation, right?
Yeah, okay.
I understand you, but try and understand me doing my own job.
Yeah.
Part of my job is you can't just record. I'm not saying it's not public, but you can't just record. For security reasons.
Yes, we can.
This is the point.
That's the thing. That's the thing. You want to enforce your stuff on. I'm telling you something that you
it's
can't
It's
do.
a lawful activity.
You're saying you can't.
It's a lawful activity.
I'm not saying do not record. I'm gonna escalate this.
Okay,
Because
escalate
normally
it.
when people come here,
Escalate
they
it
ask,
then.
can I take pictures? You say
No,
no.
I don't- yeah, but I
And
don't
they
need
respect
to.
that. But you're being.
But I don't need to.
Can't
That's the
stop-
thing.
Even on, see, in terms of things like this, if you're actually on railway property,
Yeah.
you can enforce people filming certain areas.
So if you go somewhere and
So-
you want to record, if they tell you don't record,
on the property.
Where exactly is the London Bridge?
London Bridge. Yeah, London Bridge. Stop recording. That's
No.
That's the thing, mate. If you're on
No, I'm not going to stop recording. Now what? I'm not going to stop. Now what? Aggressive.
Behaviour is relevant.
Aggressive. You're aggressive.
Do
Go on, get back to work. Get back to work. Get back to work.
Now, guard number 2 insists I need permission. Wrong again. Permission is only required on private property. Filming from public land doesn't need consent. And look closely. He starts filming me on his mobile phone. Unlike me, he is acting in connection with his employer. That makes it workplace data collection under UK GDPR. He'd need a lawful basis and a privacy notice. Did he have one? Nope.
You're not allowed to take pictures. I know you're not public, but you're not allowed to take pictures. You're not.
We are. Bylaws don't apply.
This area.
Bylaws don't apply
here,
it.
Not here.
Bylaws don't
But
apply
you're
it.
facing in here.
Yes, we are. Yes, we
You're
are.
outside,
Yes, we
but
are.
you're facing inside and front. It does matter.
It doesn't matter.
It does matter.
You're talking rubbish.
It does matter. I'm not talking rubbish.
You're
You're not
talking
allowed to
rubbish.
be filming inside.
Don't poke at me. Who are you poking at? Don't poke at me.
What are you talking
Doing
about?
that to me.
I said you're not allowed to film inside
And
there.
I'm telling you, we can. Yeah. Aggressive. Aggressive. You're aggressive. Go on, get back to work. Get back to work. Get back to work.
Guard number 3 escalates further. Bit more aggressive in tone, repeating the same false claims. His behaviour isn't just unprofessional, it may cross into harassment under the Protection from Harassment Act 1997 if it causes alarm or distress.
Oh, and I can see. Oh, I can see the screens.
And here's something serious. CCTV monitors visible from a public area. That's a data protection breach. The ICO guidance is clear. Organisations must keep CCTV feeds secure and prevent unauthorised viewing. So, to summarise the failures: false claims about the law, SIA licence not displayed, demanding personal details without cause, staff recording unlawfully, aggressive behaviour bordering harassment, CCTV monitors exposed to the public, and each of these raises compliance and professionalism concerns. So what can you do if this happens to you? Well, you can write a formal complaint to the building operator and the contractor, in this case Mitie. Report the SIA badge failure directly to the Security Industry Authority. Report the exposed CCTV and unlawful recording to the ICO. If the behaviour was aggressive or intimidating, cite the Protection from Harassment Act 1997. And if damages are caused, consider civil action for harassment or breach of data rights. Case law is on your side. In the case of Wood versus Commissioner of Police 2009, confirms filming in public is lawful. So the facts of the case. So Andrew Wood, a campaigner, was photographed in public by the Metropolitan Police officers during a demonstration. He argued that this interfered with his right to respect for private life under Article 8 of the European Convention on Human Rights, CCHR. The case went to appeal court. Now, the court's decision, the court ruled that being photographed in public does not normally engage Article 8 rights because there is no reasonable expectation of privacy in a public setting. In other words, what you do in public can lawfully be observed, recorded, or photographed. However, if the recording is excessive, persistent, or used in a way that creates harassment, Article 8 protections could be engaged. So the key principle confirmed. So filming or photographing in a public place is lawful under common law and human rights unless A. It constitutes harassment, Protection from Harassment Act 1997. It interferes with investigation or lawful activity. It breaches another law, e.g. terrorism legislation if linked to hostile reconnaissance. Why this matters. So in This case is often cited by auditors, journalists, and campaigners as confirmation that the public and the press have the right to record in public spaces. Police officers and public officials cannot lawfully stop you from filming in a public place simply because they do not like it. So, in short, Wood versus Commissioner of Police 2009 confirms that filming in public is lawful. Peck versus UK 2003 stresses that data must be handled securely and fairly. So, the background of the case. Mr. Peck was filmed by local authority CCTV in Brentwood after attempting suicide in a public street. The council later released stills from the CCTV footage to the media without his consent to demonstrate the effectiveness of CCTV. The images were widely published in newspapers and shown on television, which led to him being recognised by members of the public. Mr. Peck argued this breached his Article 8 ECHR right to respect his private life. Now, the European Court of Human Rights decision, the court held that even though the event occurred in public, the subsequent use and disclosure of CCTV footage by the authorities interfered with Mr. Peck's private life. The disclosure found to be disproportionate and unfair, especially given the sensitive context, an attempted suicide. The UK was found to have violated Article 8 of the Human Rights Act, ECHR, the European Convention of Human Rights, because the data was not handled with adequate safeguards and privacy. So the principles that were confirmed are: 1. Even in public, personal data can attract privacy protections if its use or disclosure is unfair, excessive, or damaging. 2. Public authorities must handle personal data securely and fairly. Disclosure must be proportionate and have a proper lawful basis. And 3. CCTV footage is personal data. When individuals are identifiable, meaning it must be processed under data protection principles. Today, this is linked directly to the Data Protection Act 2018 and UK GDPR. Requirements of lawfulness, fairness and transparency, Article 5.1a, integrity and confidentiality security, Article 5.1f, and purpose limitation, Article 5.1b. Now, why it matters. Now, Peck versus UK is often cited as a key case in surveillance and data protection law. It establishes that handling and sharing CCTV data without safeguards equals breach of privacy rights, even when the footage was captured in public. So, yes, in short, Peck versus UK 2003 confirms that data, including CCTV footage, must be handled fairly and securely, and that unfair disclosure can breach privacy rights under Article 8 of the European Convention of Human Rights, now mirrored in UK GDPR principles. London Bridge shows us the myths security use to intimidate the public, but the law is clear. You have the right to film. Next week, we move to pace and stop and search powers before testing them against an actual video. Subscribe now and know your rights.